Question: how will the UK government crack down on support for Hamas? In recent weeks, the UK government have warned against pro-Palestinian supporters not to express views online via social media posts or offline in public protests supporting Hamas, which the UK government have prescribed and banned. So here's what you should know about the power and the policy of the UK government to ban groups like Hamas for very common terrorism offences connected to supporting a UK banned group, examples of what would likely and unlikely amount to an offence, potential defences to these offences, and the maximum sentence for these offences. The full name of Hamas is Harakat al-Muqawamah al-Islamiyyah, Hamas. Hamas's military wing was proscribed or banned in the UK in 2001, and its political wing was banned in 2021. The independent reviewer of terrorism laws explained the policy reasons for prescribing or banning groups in the UK government in this way. Prescription is an executive decision by the Home Secretary to ban an organisation and place it on the list of proscribed organisations has both a practical and symbolic aspect. That executive order by the Home Office is made under Section 3 of the Terrorism Act 2000. I will leave for another post the arguments for and against the executive power and policy of the UK government to ban groups under Section 3 of the Terrorism Act, especially for those groups that have no operational presence in the UK. And there are many other terrorist and non-terrorist offences not mentioned in this post, including fundraising for terrorism, and also government powers to revoke visas for international students who are accused of supporting terrorism and banned groups. The first offence is support for a banned group offences. It is unlawful and a very serious crime for a person to support a banned group in the UK as per Section 12 of the Terrorism Act 2000. Under Section 12 there are in fact 6 separate offences relating to supporting a banned group. A. Inviting support for a banned group. B. Recklessly expressing an opinion or belief supportive of a banned group, more said about this later. C. Knowingly arranging a meeting to support a banned group. D. Knowingly arranging a meeting to further the activities of a banned group. E. Knowingly arranging a meeting to be addressed by a banned group supporter. And F. Making an address at a meeting to encourage support for a banned group. These offences might be committed in a public protest or a private meeting or on social media. So, for example, offending comments might include the following: telling people to support a banned group in a social media post, or knowingly inviting a banned group member or a supporter to address a meeting or a protest. What would not be an offence is where a person had no reasonable cause to believe the person in the private meeting would support a banned group, and then the person would publicly distance themselves from the comments made either at the time or shortly after. It's important to know that an adverse inference may be drawn from silence, not to challenge the speaker, supporter of the banned group about their comments at the time. It would also not be an offence if a person called for free Palestine during a lawful and peaceful protest, or send a social media post about the importance of a Palestinian homeland, or attend a vigil to show general solidarity with the Palestinian people to mourn the loss of innocent lives killed as a result of the bombardment, siege and starvation. However, specific care should be taken expressing opinions and beliefs which may share the same or similar vision and goals of a banned group, so as not to fall foul of Section 12(1)(a), recklessly expressing an opinion or belief supportive of a banned group. The maximum sentence for each of the 6 Section 12 support of a banned group's offences is 14 years in prison. 2. Glorifying terrorism offence. Section 1 of the Terrorism Act 2006 makes it an offence for a person to glorify acts of terrorism, including the acts of terrorism of a banned group, even if the acts of terrorism took place abroad. The offence can be committed quite easily by making a statement which either intends the public to be direct or indirectly encouraged to commit acts of terrorism, or is reckless as to whether the public will be directly or indirectly encouraged to commit acts of terrorism. And indirectly encouraging the public to commit acts of terrorism includes statements which glorifies acts of terrorism, which has been defined as praise and celebration, which should be emulated. So, for example, a person could be considered as committing the Section 1 acts of glorifying terrorism offence if A. They express joy and happiness at the killing of and injury of innocent people regarding the reported acts of terrorism associated to a banned group. Or B. Making a prayer to praise either the banned group and or its members who have been killed in action. It would not be glorifying acts of terrorism if a person were to explain the history of the banned group, its links to foreign states, to provide an explanation, not a justification of what the banned group has done or is doing, or praying for children, women, families and men who have been innocently killed, or praying for peace against oppression and occupation. But a person would need to be very careful indeed, making comments about a banned group so they are not misunderstood by others. The others may be young people, immature and naive on social media a person is posting on. Or the others may have a malicious motive for attending a protest to draw out an unguarded and careless comment from the person about the violent and terrorist acts of a banned group. The maximum sentence for a Section 1 glorifying acts of terrorism offence in the UK is 15 years in prison. 3. Section 13 terrorism clothing and flag offences. Section 13 of the Terrorism Act 2000 makes it an offence to wear clothing or carry or display articles in public in such a way or in such circumstances to arouse reasonable suspicion that the individual is a member or supporter of a proscribed organisation. So, for example, a person who waves a flag of a banned group during a protest would commit a Section 13 offence. A defence to this offence is to argue that they were not waving the flag of a banned group, but another flag of Palestine. And finally, 4. Section 13(1)(a) terrorism social posting. A person commits a Section 13(1)(a) offence to publish an image of an item of clothing or other article, such as a flag or logo, again in such a way or in such circumstances as to arouse reasonable suspicion that the person is a member or supporter of a proscribed organisation. For example, posting a picture waving a flag of the banned group. But while it is not an offence in itself to share imagery of a banned group, again, care needs to be taken as to who the sharing is with, that is, the recipient, so as not to arouse reasonable suspicion that the person is a member or supporter of a proscribed organisation. The maximum sentence for Section 13 and Section 13(1)(a) offences is 6 months in prison and a fine. Please seek specialist legal advice if you are contacted by the police in respect of these and other offences, or you are not sure what you can and cannot say. Feel free to comment, follow, like and share.